Private Quickie. A lot of times you'll hear people justify censorship or discrimination by companies on the grounds that they're private. And since constitutional amendments like the 1st, 5th, and 14th only apply to government, it's not unconstitutional for private companies to do it. But there's an exception, as the Supreme Court decided unanimously in Norwood v. Harrison. A private company can be considered to be a state actor if the state incentivizes them to do so or threatens them with some sort of penalty when they don't. The case came about when Mississippi provided textbooks to private schools that discriminated on the basis of race. Parents argued that the state was supporting discrimination, a violation of the Equal Protection Clause. The district court disagreed, saying that the textbook program wasn't about racial segregation, but providing aid to students who attended private schools. But the Supreme Court said that didn't matter. Government resources and taxpayer money cannot be used to fund activities that violate the Constitution. Otherwise, they'd be doing an end run around it. Oh, see, we didn't do it. We just gave a tax subsidy to companies that did. But that's the point where private activities become state action. More recently, attention has been focused on social media censorship. Defenders say that this is legally kosher because they're private companies. But at least sometimes that's been shown not to be the case. Politicians in Congress and the White House have publicly pressured social media companies to censor more in accordance with their own views of what should and shouldn't be said. When politicians give press conferences or take to Twitter to call for certain voices to be silenced, they aren't just giving a personal opinion. They have the full force of government behind them. Social media companies acting on that, therefore, become state actors. But Norwood v. Harrison ruled that Congress may not induce, encourage, or promote private persons to accomplish what it is constitutionally forbidden to accomplish. For more than half a century, courts have held that government threats can turn private conduct into state action. So before you go and defend a private company's censorship or discrimination, you might want to take a peek behind the curtain and see who's really directing the decision.